think we're gonna go ahead and get started. Thank you all for joining us this morning and welcome to day 3 of our VAWA training series. Today we're going to be talking about federal, state, and CoC policies. My name is Byla Lindner, and I'm also joined today by my colleague Nicole Thomas, who's going to be helping out with the chat box and technological things. Just as background, in case you aren't aware, Homebase provides technical assistance to the Office of Supportive Housing and housing and homeless services providers throughout the county. So really quickly, I just wanted to go over the objectives for today's training. First of all, we're hoping to help provide an understanding of the goals and requirements of the Violence Against Women Act and how it applies to CoC funded programs. We want to help you become familiar with the CoC's relevant quality assurance standards. We want to help you learn about the confidentiality and privacy protections for survivors of domestic violence and other forms of intimate partner violence, and to help you become aware of some additional protections for survivors under California housing law. So our agenda for today is that we're going to start with an overview of the Violence Against Women Act, or VAWA. Then we're going to talk about applying HUD's VAWA final rule to CoC funded programs, including required contract terms and notices to clients, and emergency transfers. We are going to talk to communicate with you. Oh, sorry. We're going to be talking about some relevant Santa Clara County CoC quality assurance standards, and then do like a very, very brief sort of mini informational slide on California housing law protections for survivors of domestic violence. So before we get started, I want to go over some tech reminders. I'm sure a lot of this is, basically in your brain already, but because we're all on Zoom all day long anyway. But I just wanted to give everyone a heads up again that we are recording this training. This recording will be made available online, as will all the slides. You all are muted upon entry, and we ask that you stay muted unless you need to unmute to ask a question. If you're having technical issues, please use the chat box to message my colleague Nicole Thomas. She will be available to assist you guys. Feel free to also ask questions in the chat box. The chat box is not going to be recorded. And I will also pause for questions throughout the training as well. We may not get to all of the questions today, but whatever we don't get to, we'll take note of and be sure to answer at a later time. I also wanted to note for folks that we have closed captioning available, so let us know if you need assistance accessing that. Really quickly, I also wanted to give a content advisory to everyone. This training is obviously about intimate partner violence and domestic violence. It covers sensitive issues that might trigger people or otherwise make people feel distressed emotionally, and I really want to encourage everyone to take care of yourself today. If something that you hear or see upsets you, to just make sure that you take the time to take care of yourself. Also, please feel free to take great breaks, go off camera. As I said, everything's going to be recorded, so you can always catch up on material at a later time. And like I said, the chat box is not recorded. So if there's something that is sensitive that you want to share, you can feel free to share it in there. It will be seen by everyone who's here today, but it won't be recorded and put online. And also feel free to change your name on Zoom if you want to remain anonymous during this training as well, with whatever you share or questions you ask. Okay, so getting right into the Violence Against Women Act, the federal regulatory landscape. So before we get into HUD's particular requirements for people implementing VAWA, I wanted to talk about the Violence Against Women Act as a whole, because it's a large piece of legislation that includes a lot of different pieces. I'm not going to talk about all of them, but I just wanted to give you a little bit of context about what it is, the history behind it, the ideological context, and some definitions. So what is the Violence Against Women Act, or VAWA? It's landmark legislation that was initially passed in 1994. It was also reauthorized in 2000, 2005, and 2013. And I actually just learned that it was reauthorized again yesterday, which is excellent news because there was some possibility that there may be difficulty with reauthorizing it, but it was reauthorized. I haven't had a chance to look at the reauthorization, but if there's anything that needs to be updated about this training, we will certainly send out information about that to folks. So VAWA has grown stronger and broader with each reauthorization. And initially, VAWA was passed in recognition that domestic violence was an epidemic, that it was becoming a huge problem in the country, and that a federal response was necessary. So the provisions, like I said, in the Violence Against Women Act are huge. There are so many different parts of it, so many protections for folks. You know, perfect piece of legislation by any means, but it's what we have. But what we're going to talk about today are VAWA's protections for survivors who live in HUD-funded programs. And those regulations were implemented by the HUD final rule, which was implemented in November of 2016. And the ideals behind the final rule are that basically everyone should have a home free of violence. There's no reason why anyone should have to leave their home or stay in their home, you know, because of domestic violence. We should all be able to have a safe home where we're not put at risk. Also, it's very important for us in our communities to work to decrease instances of homelessness caused by domestic violence. So that's really what we're talking about today. That's the whole reason that we're here. So who does VAWA protect? VAWA protects survivors of domestic violence, stalking, dating violence, and sexual assault. It protects survivors regardless of sex, gender, race, national origin, or sexual orientation. So again, this means that while it's called the Violence Against Women Act, it's not just about women. Anyone can be subjected to domestic violence, so it protects all sexes and genders. A couple of additional things I wanted to point out is that alleged perpetrators do not have to have been convicted of any crime for survivors to be protected. So if someone is a survivor and they've experienced domestic violence, they're still protected by VAWA, even if that abuser hasn't been convicted or prosecuted or anything like that. VAWA also protects people affiliated with survivors. So that can be children, that can be spouses, siblings, parents, and anyone else residing in the home with the survivor. So it's not just about the survivor, it's about other people who are affiliated with them as well. I wanted to provide VAWA's definitions because they have their own definitions for domestic violence, dating violence, sexual assault, and stalking. So domestic violence are crimes of violence committed by a current or former spouse or intimate partner of the victim, by a person with whom with whom the victim shares a child in common, or by a person who is cohabitating, living with, or who has cohabitated with the victim as a spouse or intimate partner. Dating violence is violence committed by a person who is or has been in a social relationship of a romantic or intimate nature with the victim. Sexual assault is any non-consensual sexual act prescribed by law, including when the victim lacks capacity to consent. And stalking is conduct directed at a specific person that would cause a reasonable person to fear for the person's safety or the safety of others, or suffer substantial emotional distress. I want to note that in this training, I'm going to be using the term DV survivor or domestic violence survivor to refer to anyone who fits under any of these categories, just for brevity's sake. But when I say that, I'm referring to all of these folks. Does anyone have questions so far? Okay. All right, now on to HUD's VAWA final rule and the Santa Clara County CoC quality assurance standards that are relevant. So I've broken down the final rule's key safeguards into 3 sections. The first one is the core housing protections. The second is required notices and contract terms. So that's the terms that have to be in leases, occupancy agreements, and the notices that have to be provided to people when they, at various points in time, while they're associated or affiliated with your program, and emergency transfer plans. So the core housing protections of HUD's VAWA final rule include that survivors cannot be evicted or denied housing solely because of their status as survivors. Survivors cannot be evicted or denied housing solely based upon factors directly related to victimization. So this is really interesting because it means that if a survivor is in a situation where they're being evicted, and if they can show that their current or past victimization led to an adverse factor, so for example, lack of credit, lack of work history, criminal history, that factor cannot be the basis for a denial or eviction. So it's not just about being evicted or denied housing solely based on the fact that you have had an incident of domestic violence perpetrated against you, but also all of those other things that can result as that can come about in someone's life as a result of being a survivor of domestic violence. And again, this is just so important because this policy helps mitigate and offset some of those financial and social harms that DV survivors experience at the hands of their abusers, right? It can be financial, it could be preventing people from working, it could be preventing people from having jobs and getting, references. It's very hard to obtain housing when you don't have credit, that kind of thing. So it's sort of making sure that there's not this extra level of difficulty in obtaining housing or in keeping housing because of all these things that happen in addition to the violence and control.
Viola, I'm seeing a question.
Oh, sure.
Is that for survivors of sexual assault as well?
It is, yes. Yes, that's for all of the categories that I was talking about before, survivors of domestic violence, dating violence, sexual assault, and stalking. Yes, good question. So there are some limitations of VAWA protections, right? People who are survivors of domestic violence can still be evicted. Okay, it doesn't mean you can never evict someone or deny housing to someone who's a survivor. So a program participant may be terminated or evicted for any violation not based on an act of DV against the tenant or an affiliated individual, so long as the tenant isn't subjected to a more demanding standard than other tenants. So what this means is that a landlord or a program cannot make someone who is a survivor of domestic violence jump through extra hoops or hold them to a higher standard than other tenants when considering eviction. So it's about removing discrimination, essentially. Survivors can also be evicted if the housing provider can demonstrate an actual and imminent threat to other tenants, employees, or service providers. So I have a definition of actual and imminent threat here. I'm not going to go through it, but that's where the definition is for your reference. And something to remember here is that when making claims about public safety, when a landlord or a provider is saying that this person is posing a threat to public safety or their situation is posing a threat to public safety, it's really important that landlords and housing providers, they can't base their claims on stereotypes, right? So for example, they have to base their claims on particular and real concerns related to this tenant. So what that means is that they can't say, I know that people who are survivors of domestic violence bother other tenants, or I know that, people who are subject to domestic violence, that their abusers end up being harmful to other people in the building. It has to be related to something that is actually, related to this tenant and not based on some stereotype that someone may have about the tendency of people who are experiencing domestic violence. And I'm going to pause again for questions. Does anyone have questions so far? Another core housing protection is that eviction or termination should only be a last resort. So eviction or termination of assistance should only occur when there are no other actions that could be taken to reduce or eliminate the threat. including but not limited to transferring the survivor to a different unit. And we'll talk about emergency transfers in a moment. Barring the perpetrator from the property, contracting law enforcement to increase police presence or develop other plans to keep the property safe, seeking other legal remedies to prevent the perpetrator from acting on a threat. And what this really ties back to is housing first in some way, because what we're really trying to do here is prevent the loss of housing. We want to make sure that we're taking a non-judgmental, flexible, client-centered approach to the assistance, because as we've heard in the last sessions, not everyone wants to leave their abuser, not everyone can leave their abuser. And so we want to make sure that, and it's not always safe to leave your abuser. We want to make sure that housing is not lost as a result of what someone is experiencing in their housing. And one such option that I referred to is, barring the perpetrator in some way. One way to do this is to ask the landlord to bifurcate or split the lease to evict the perpetrator while allowing the survivor to stay. And you could do this in a couple of different ways depending on the type of housing that you're providing. When it's tenant-based rental assistance and leases are bifurcated, the rental assistance and any utility assistance continues for the family members who are not evicted or removed. So assistance continues for the survivor. In permanent supportive housing, if the family's eligibility for that housing was based upon the evicted or removed family member's disability or chronic homeless status, it gets a little bit sticky. The remaining family members may stay in the project through the end of the lease and be given the opportunity to demonstrate their eligibility independent of the person who was evicted. When you're bifurcating a non-TBRA lease, participants who have not already established independent program eligibility at the time of bifurcation have 90 days to establish their eligibility or locate other housing. Does anyone have questions about lease bifurcation?
There was another question that came in through the chat asking what kind of verification would the survivor need to demonstrate? Would the survivor need to have a police report to demonstrate they are a survivor?
So that's a really excellent question. And we're going to get into that in a minute when we talk about emergency transfers. But essentially, COCs, for the CoC part, CoC funded programs, you can continue to support, well, let me walk that back a minute. It's up to the program. HUD does not require documentation. This is one of the few places where HUD says we don't need documentation, because it's already so hard for people in these types of situations to come forward and ask for assistance, let alone to document it. They may not want to call the police. They may not want to come to court. That HUD has said we're not requiring documentation beyond a self-certification that the person is a domestic violence survivor. And I'll get into that in a minute, what that looks like. So it's basically a self-certification. CoC funded programs can ask for more documentation if they wish within certain parameters. But in general, people do not have to provide more than that self-certification. Okay, so we're now going to turn to an overview of the required terms that have to be in various rental agreements and the notices that have to be provided to program participants. So all households receiving CoC funded assistance have to receive a notice of occupancy rights and certification form at each of the following times. And that certification form is the form I was just referring to. They have to be provided those forms when they're denied assistance, when the household is admitted to your program, when the household receives a notice of eviction, and when the household is notified of termination of assistance. And who has to provide those documents depends on the type of housing, and I'll provide some information about that in a second. But a little bit more about the notice of occupancy rights. That explains VAWA protections, including the right to confidentiality and limitations of those protections. The certification form, as I said, is to be completed by the survivor to document the incident and to certify that they are a survivor of domestic violence, dating violence, sexual assault, or stalking. And model forms are available on the HUD portal in various languages, as well as on the CoC website. And again, just taking it back to policy here for a second, the reason these notices and forms have to be provided at all these different points in time is that domestic violence is unpredictable. You never know when it could happen. It could happen to anyone. And so we don't want to assume that certain people might need these or not need these. They need to be provided to everyone at all of these different times to make sure that people also know what their rights are and what they need to do if something happens. So this is where it gets a little bit nitty gritty in terms of when those documents need to be provided to people, or rather who needs to provide those documents to people. This is a very, very dense subject, and it doesn't lend itself well to a Zoom training. So what I've done here is I have this slide. We're also going to provide a handout that you can go over on your own at your own leisure. And also we are available if you have any questions, if anything's unclear, but we recommend that that you look through these and reach out to us if you have any questions. Most of these issues are handled by VAWA lease addendums, which I think most programs are already using. And so, you know, again, not going to go through this. It's super dense. Your eyes will glaze over. We don't want that to happen. So pay attention to the slide at your leisure. And we're also, like I said, going to have a handout that explains this in a lot of detail, and we'll make it clear to you. And again, this slide talks about the applicability of those terms as well. And basically, it should apply to anyone at this point in time. All CoC funded programs. Okay, moving on to emergency transfers and Santa Clara County's CoC's policies on those. So what is an emergency transfer? VAWA emergency transfers quickly relocate DV survivors receiving assistance who believe there is an imminent threat of harm from further violence should they remain in their home, or survivors who were recently sexually assaulted in their home. There are a few key terms that I want to make you familiar with as well. The first one is internal emergency transfer. That's when an emergency relocation occurs of a tenant to another unit where the tenant would not be a new applicant. So in other words, transfers within a program just to a new unit. Or across programs with the same eligibility requirements, but essentially within the same program. External emergency transfers are emergency relocations of tenants to another unit where the tenant would be considered a new applicant. So they would have to reapply for that program. A safe unit is the unit that the domestic violence survivor believes is safe. And again, this is about centering the choices of the survivor, letting them sort of be in the driver's seat and making the calls about what they think is safe. It's not about what I think it's safe. It's not about what you think is safe. It's about where and how they feel safest in their unit. So we're going to speak really broadly about the CoC's obligations with regard to emergency transfers now. So each CoC has to establish an emergency transfer plan to quickly relocate DV survivors receiving CoC funded assistance. They have to make that emergency transfer plan available to tenants and the public. And they have to keep a record of all emergency transfer requests and outcomes of all those requests for 5 years and report them to HUD annually. Santa Clara County's CoC emergency transfer plan is on page 78, I believe, of the current quality assurance standards, and those are available on the CoC website. I certainly invite you all to have a look and read through that in its entirety as well. I pulled out a couple of policies, though, to talk about right now. So the first one is who qualifies for an emergency transfer in Santa Clara County. A client qualifies for a VAWA emergency transfer if they are a survivor of domestic violence, dating violence, sexual assault, or stalking, they expressly request the transfer. So again, putting them in the driver's seat, they request the transfer. And either they reasonably believe there's a threat of imminent harm from further violence if they remain in the dwelling unit, or if they are a survivor of sexual assault, the sexual assault has occurred on the premises during the 90 calendar day period preceding the date of the request for transfer. Does anyone have questions so far?
There is a question in the chat. Can you share what a survivor can do if their landlord or property manager does not comply with these VAWA protections and orders?
So that's a really good question. I think it depends on what they're not complying with, particularly if they're not complying with something that has to do with the housing protections. I think I would recommend that you refer them immediately to a housing attorney who can help try to figure out if there's a way to enforce those protections. Without knowing more about the particular non-compliance, as I said, it's a little tough to answer that question. Maybe you can provide some more detail about your concern.
Transfer requests to another unit specifically.
To another unit controlled by that landlord?
Yes.
Okay. I don't know that they have a right to another unit controlled by that landlord. I don't know that that's an enforceable right covered by VAWA. What I would say is that the emergency transfer plan gives people puts the obligation on the CoC and the program to transfer someone to a new unit. It doesn't put the obligation, I think, on the landlord to provide another unit, if that makes sense. But again, with matters of landlord-tenant law, I'm not an expert on those issues. So if there is a particular concern about a relationship with a landlord, I would definitely recommend reaching out to one of the housing law experts in the community, like Bay Area Legal Aid or the Law Foundation. Okay, so what is the process for getting an emergency transfer? The survivor should submit a written request to program staff certifying that they meet the emergency transfer qualification requirements. And again, the program can ask for additional documentation additional to that certification, but no other documentation is required. Program staff must communicate with their coordinated assessment system matchmaker at the Office of Supportive Housing to inform them that an emergency transfer request has been made and whether the request is for an internal transfer, external transfer, or both. And all they need to tell the matchmaker is that it's an emergency transfer request. They're not to say anything about the fact that it's domestic violence related or provide any details about the domestic violence. And I'll get into that a little bit later, those confidentiality protections. So you can pursue an internal transfer, an external transfer, or both at the same time, depending on what your client wants to do. When they request an internal emergency transfer, the program has to take steps to immediately transfer them to a safe unit if it's available. Requests for internal emergency transfers should receive at least the same priority as the program provides to any other type of transfer requests that they have. And if a unit is not immediately available, inform the survivor that their options are to wait for a safe unit to become available for an internal transfer, request an external emergency transfer, or pursue them both at the same time. So it sounds like maybe this is getting at a little bit of what the person who asked the question is talking about, that if there isn't a safe unit available, like if the landlord doesn't have a unit or they're not offering it or providing it, then perhaps going an external emergency transfer or giving the client the opportunity to decide what they want to do. If they want to stay in their unit, wait till one becomes available within their program, just different options that they have. And where a participant requests an external emergency transfer, so to a different program, the survivor has priority over all other applicants within the whole CoC for CoC funded housing assistance. So the CoC takes this very seriously. This gets them, top priority. And then the matchmaker who is assigned to the program type will facilitate the referral of the survivor to the next available appropriate programming unit. The household retains their original homeless or chronic homeless status for the purpose of the transfer. So going to some of these confidentiality provisions that I alluded to, any information provided by a participant when they request an emergency transfer, including the fact that domestic violence occurred, must be kept in strict confidence by the recipient. This is very, very important. No employees or contractors may have access to that confidential information unless it's explicitly authorized by law. The information must not be entered into any shared database or disclosed to anyone unless the disclosure is requested or consented to in writing by the individual in a time-limited release, required for use in an eviction proceeding or hearing regarding termination of assistance, or unless otherwise required by applicable law. So in sum, besides the person receiving the request at your program and anyone else at the agency who absolutely needs to know that you're requesting an emergency transfer related to domestic violence, no one else must know about the domestic violence details of the request. It needs to stop right there. This means that the landlord doesn't have the right to know the details of the emergency transfer. And even, like I said, the matchmakers shouldn't be privy to the details of the domestic violence. All emergency transfers within the CoC have the same priority, so the matchmakers really don't need to know. And one of the reasons behind all these confidentiality requirements is that confidentiality and privacy is paramount when we're dealing with people who are trying to flee domestic violence. If their abuser or someone else who knows the abuser catches wind that they're trying to escape, or that they're moving or where they're moving, it could be catastrophic and become very dangerous. One last thing to note about confidentiality: programs have to ensure strict confidentiality measures are in place to prevent the disclosure of the location of the client's new unit to their abuser. So again, this is just more driving home the fact that it's really about keeping this information confidential strictly. Does anyone have questions about emergency transfers or those confidentiality provisions? I wanted to quickly touch upon the CoC's coordinated assessment confidentiality requirements, because although this is more of an issue for training on the VI-SPDAT and a coordinated assessment, it's relevant to what we've been talking about with regard to policies that safeguard DV survivors within the CoC. Nicole, was there a question that just came?
A question did come in.
Okay.
When the DV survivor is transferred, will the household members who are left in the original housing unit lose their TBRA support?
So if it's TBRA, the remaining folks, they should not lose their support. They should not lose their support. I mean, in that situation, I think it gets a little bit muddy if the eligibility was tied to the person who's not transferring. We've definitely looked into this question before. Unfortunately, I don't want to misstate the answer, so I'm going to put that on ice for now. But we will send out a response to that question, because it gets a little bit complicated depending on who is eligible. But I believe that they would definitely maintain their eligibility if they were the person who was originally eligible and the head of household. Does that make sense? I hope that makes sense. We will clarify later via email the answer as well.
There is another question. Why would we transfer a client's program if they are already enrolled in our program and we house them?
Yeah, so that's a really good question. People may feel unsafe for some reason with the program. maybe their abuser is tight with someone in the program, and or they're just have concerns about safety in the program. There could be any number of reasons why people want to switch programs. But basically, it's about putting the survivor in charge of their own sort of decision making. And if for some reason they feel that they want to switch to a different program because they think that that'll provide them with an extra level of confidentiality and privacy to just completely separate from that program, then that might be necessary for them. And also, there might not be a unit. There might not be that program might not be able to find them a safe unit as quickly as another program might, if that makes sense.
They're saying, so we would first try to rehouse them while still in our program, but if they request to change programs, that is when we ask for a program transfer.
So it's up to the client. You need to offer them the option of staying in the program and doing an internal transfer, or doing an external transfer, or doing both and seeing what rehouses them quickly to a safe unit. So you need to put it to the client to decide. Maybe they don't want to even bother with an internal transfer. It's really about letting them know these are your options, and letting them decide.
They're saying thank you.
Okay, great. Any other questions about emergency transfers? Okay. So again, just reiterating that I'm going to be talking about coordinated assessment confidentiality safeguards. A lot of this, like I said, I think is covered in the current VI-SPDAT training, and talking about the DV pre-screening tool and identifying survivors at access points. But I just wanted to call out this one policy for you all because it's relevant to what we're talking about. And the one policy that I'm calling your attention to is the policy for when a survivor presents at a non-victim service provider. So an access point where you don't, where it's not your main mission to serve survivors of domestic violence. So you're not YWCA, you're not Community Solutions, you're not OCCI, you're not a victim services provider, but someone who is a survivor comes to you and says, I want to be assessed. So in these situations, the program should follow this procedure. They should offer the choice of making an immediate warm handoff to a victim services provider for services, including safety planning and the VI-SPDAT. So saying, I've identified that you're a domestic violence survivor, not using those words, but basically, offering them the opportunity to go to the VSP to be assessed and to receive services. They can continue to assess them. You can continue to assess them using the VI-SPDAT at your agency, and then you can enter their information anonymously into the community queue in HMIS. Or you can continue to do the VI-SPDAT at your agency and enter their information as usual in HMIS. So they're basically those three choices. And again, the theme here is making sure that the survivor is aware of all the choices that they have, and then the ball is in their court to make those decisions about how their data is stored and who is serving them. And if a DV survivor who is already in the community queue because they've undergone like a family VI-SPDAT with their abuser, so they already have a VI-SPDAT on file, but it's a family VI-SPDAT and their abuser is part of that household, they should be given the option to be reassessed without the abuser, if they so choose. Does anyone have questions about that? So I'm going to really quickly touch upon a couple of California state housing laws, just so you're aware of them. These are laws that offer some additional protections to survivors of domestic violence. So the first one has to do with changing locks. Landlords are required to change locks within 24 hours of receiving a request in writing and a court order excluding the abuser. So an order of protection, order of exclusion, or a police report if the abuser does not live with the survivor, issued within 180 days. If the landlord does not change the locks, the survivor may change them themselves. Go ahead and do that. They don't need permission from the landlord. This is really about making sure that people can, get safe as quickly as possible, and they don't have to wait for their landlords to, send over the maintenance person or do whatever they need to do to change the locks. It's in the the survivor's hands. A landlord cannot evict a tenant based on their status as a DV survivor unless, after having used the defense that they are a DV survivor, the tenant persists in allowing the abuser onto the property. So, for example, a landlord cannot evict someone, saying, "I know that you have been experiencing domestic violence in your unit. I want you out," and then the survivor continues to allow the abuser onto the property. This, I think, is a little bit complicated, and for all of these, I'm going to recommend that that if this is a situation that you're dealing with a client, or that your client is dealing with rather, that you reach out to a housing law attorney immediately, to try to get more detailed information and to get some actual legal advice from them. But this is just kind of to put these things into your mind, so that if you come up with this situation with one of your clients, oh, okay, this is something I can speak to someone else about. A landlord cannot evict a tenant unless, a landlord cannot evict a tenant based on their DV status based on their status as a DV survivor, unless they reasonably believe that the abuser poses a threat to other tenants. And the landlord must provide the tenant with at least 3 days notice to allow them to correct the violation that they believe is occurring. So I apologize, that was a little bit muddy. I'm not a housing law expert, but again, this is just to put this in your mind so that if something occurs, to refer your clients to the appropriate attorneys if need be. So does anyone have questions about anything that we've talked about? I know it's been super dense, and there's a lot that we've covered. So any additional questions?
I have one.
Oh,
Yes.
Sorry. So, what if a DV client is housed, but that client, the DV client, is the one causing issues on on the property? Is the landlord still able to not renew the lease due to the VAWA, or how would that work?
I think so. What it sounds like is you're saying that someone happens to be a survivor of domestic violence, but they're also causing other problems on the property that are unrelated to domestic violence. Is that what landlord?
And the lease is up, and the landlord does not want to renew the lease with the client. Is that allowed?
So that sounds to me like a housing law question, and a question about what the lease says, whether it's automatically renewable.
Okay.
But I will say, just going back to some of the limitations of VAWA, people can still be evicted
Okay.
for other reasons, right? If they're destroying the property, if they're otherwise breaking lease terms, it's not, it doesn't, you can still be evicted.
Other ways?
If there are other problems, I guess.
Got it. Okay.
This is about protecting people from being evicted for issues stemming from domestic violence.
Okay. Got it. Thank you.
Yeah, sure.
There was another question relating to the last slide on housing law. So where it says, if the victim allows the abuser on property, Do they mean into the unit to visit? Because I would imagine the victim can't keep the abuser from coming to the property. Is it referring more to the abuser being invited by the victim? Or
I think it is about the survivor allowing the person to continue to come onto the property after being warned that they're not supposed to be on the property. If the abuser shows up on the property, there's nothing that the survivor can do, and that is about the abuser being in the wrong. And that is, a classic situation where it's the DV survivors being harassed, and they should probably request an emergency transfer so that they can get away from the abuser. But I don't think this law was intended to give landlords an excuse to evict people because their abusers are showing up without their permission, if that makes sense.
yes, it makes sense.
Okay. Any other questions?
I'm happy to continue reading them out loud, but to the extent that you feel comfortable, please feel free to come off mute and ask your questions.
And again, if you want to take your time to review these slides, review the handout that we're going to be sending out on those lease terms and contract terms. If there's something in there that doesn't make sense, or you think about it later and you think, wow, I wish I'd asked that question, or if you don't feel comfortable asking a question right now, please always feel free to reach out to us at our email address. And we will get back to you. And again, we will address the question about the emergency transfer of the TBRA at a later date, as soon as possible. Yeah, so I guess if that's it, we are just going to go ahead and put a feedback survey link there. There she goes. Nicole just put a link in the chat. We love getting feedback from you all. We love hearing about ways that we can improve our trainings. So please let us know what you think. And yeah, just thank you all for your questions today. Thank you for coming. And we hope you all have a good rest of your day.